Swayam Prabha. Digital India. Educated India.
Now 94 talks about termination. Termination of a license. 1. On an application made by the patentee or any other person deriving title or interest in the patent, a compulsory license granted under 84 may be terminated by the controller if and when the circumstances that gave rise to the grant thereof no longer exist and such circumstances are unlikely to recur. So, the patentee can approach if the circumstances of grant no longer exist. Say, if the only ground on which the grant occurred was the fact that it was not locally manufactured, and the patentee after a year or so starts local manufacture, then the patentee can approach the patent controller to say that now that local manufacture is addressed by me, the grant can be revoked, provided that the holder of the compulsory license shall have the right to object to such termination. So, again there is some kind of an opposition proceeding here. If the patentee makes an application for termination, the right holder, the compulsory licensee, can oppose it and he can object to it. 2. While considering an application under subsection 1, the controller shall take into account the interest of a person who had previously been granted the license is not duly prejudiced. So, in looking at a termination, it will ensure that the rights of a person who is enjoying the license is not unduly prejudiced. Now, there are certain rules pertaining to the chapter on compulsory license. Now, 96 states that an application for a compulsory license under section 84 or 85, 91, 92 and 92A. You should understand that though section 85 is mentioned here, section 85 is not an application for a compulsory license, rather it is an application for revocation. But nevertheless, since 85 is tied to 84, you find that 85 is also mentioned here. So, shall be in form 17 or form 19 as the case may be. So, there are two forms, form 17 and form 19. Except in the case of an application made by the central government, the application shall set out the nature of the person's interest and the terms and conditions the applicant is willing to accept. So, if a government makes an application, there is no need to mention the interest. If a person or a party other than the government makes an application, then the terms and conditions he is willing to accept and he should set out the interest involved in the patent. Now, 97 states when a prima facie case is not made out. Now, we saw that in section 87, the procedure dealing with the grant of compulsory licenses, the first requirement is that the controller has to be satisfied that a prima facie case has been made out for making an order. So, the prima facie or preliminary or initial satisfaction by the controller is a requirement for proceeding with an application under 84 or 85. If the controller is satisfied that a prima facie case has not been made out for making an order under any of the sections referred to in Rule 96, which are the 5 sections, he shall notify the applicant accordingly, and unless the applicant requests to be heard in the matter within 1 month from the date of such notification, the controller shall refuse the application. So, the procedure for rejecting an application for compulsory license is that if the controller is of the opinion that it is not satisfied the requirements under 97, then which is a prima facie case is not made out, then he shall notify the applicant, and if the applicant wants to be heard, he will hear the applicant, and within 1 month from the date of such notification, the controller shall refuse the application. So, this is a requirement for the controller. If the controller feels that a prima facie case is not made out, then this is the procedure that he will follow. He should hear the applicant if the applicant wants to be heard, and within 1 month of the notification he can pass an order of refusal. 97.2. If the applicant requests for a hearing within the time allowed under sub-rule 1, the controller shall, after giving the applicant opportunity of being heard, determine whether the application may be proceeded with or whether it shall be refused. So, he shall hear the applicant and then decide whether to proceed or to refuse. 98, we had seen that there is an opposition proceeding envisaged in section 87. The patentee can oppose an application for a compulsory license on his patent. Now, we also saw that the normal form is form 14 for any other opposition other than an opposition under the post grant provisions, which is form 7. A notice of opposition under subsection 2 of 87 shall be given in form 14 and shall be sent to the controller within 2 months from the date of publication of the application under subsection 1 of the said section. The publication mentioned here is when the controller feels that a prima facie case has been made out, he will direct the applicant to serve copies on the patentee and shall publish the application in the official journal. So, official journal is different from the gazette. Official journal is the journal of the patent office, which is published every Friday. An online version is available in the website, patent office website. So, when an application is made for a compulsory license and the controller is satisfied there is a prima facie case, then he would publish the application in the official journal. Now, once this publication happens, the notice of opposition shall go to the controller within 2 months from the date of this publication. That is a timeline given for the patentee to oppose. 2. The notice of opposition referred to in sub-rule 1 shall include terms and conditions of the license, if any, the opponent is prepared to grant to the applicant and shall be accompanied by evidence in support of the opposition. Now, when the patentee opposes, the patentee can also state the terms on which he is willing to grant a license. In some cases, a licensee or an applicant will approach for a compulsory license because he is not able to get a license from the patentee, or the patentee is not willing to give it on reasonable terms as the applicant feels. Now, if there is a difference between the two parties, the patentee who wants to give a license and the applicant who wants to take the license with regard to the royalty rates, then by opposing the application for compulsory license, the patentee can also indicate what are the terms that he wants. So that the controller can also consider, if a license is to be granted, what are the terms on which the patentee is willing to grant it. So, while sending the notice of opposition, the opponent, that is the patentee, can also include what are the terms and conditions that he wants to get into the license. 3. The opponent shall serve a copy of the notice of opposition and evidence on the applicant and notify the controller when the service has been effected. 4. No further statement of evidence shall be delivered by either party except by leave of or on requisition by the controller. So, once the opponent serves his statement and evidence, there won't be any further evidence. The controller shall fix a date and time for hearing of the case and shall give parties not less than 10 days notice of such hearing. This is a normal practice. When the pleadings are completed, when the evidence is in place, the controller shall notify and give 10 days of notice for hearing. The procedure specified in sub-rules 2 to 5 of Rule 62 shall, so far as may be, apply to the procedure for hearing under this rule as they apply to the hearing in opposition proceedings. And we have seen that the provisions for post-grant opposition will normally apply for every other opposition. Now, the manner of making a publication of revocation under section 85 shall publish the order made by him under subsection 3 of section 85 revoking a patent. So, a revocation under 85 shall be published. Now, rule 100, 101 deal with the procedure to be followed when under section 88. In section 88 describes the powers of the controller in granting compulsory licenses. Under 84 when the and 88 is also relevant for the other types of compulsory licenses. Now the controller shall take into factor whether the person is an existing licensee, or if he is an existing licensee, whether to keep the existing license intact or to cancel it. There are various powers that the controller has. Now 100 and 101 details the procedure to be followed when there is an application under 88.4. 88.4 pertains to the revision of terms of a compulsory license that has already been granted. We had already mentioned that once a compulsory license is granted, the licensee will have to work it for at least 1 year, and after 1 year, that is 12 months, he can approach the controller to revise the terms and conditions, because on the ground that the terms have proved to be onerous and he is not able to work the invention except at a loss. So 88.4 deals with the revision of terms of a compulsory license, and there is an application under form 20 and there is a procedure. So 100 and 101 cover the application and the procedure when you need to seek a revision of the terms of a compulsory license that has already been granted. Now 94 we saw that a compulsory license granted can be terminated. There is an application for termination which is form 21, and the procedure that has to be followed is detailed in rule 102.